Sumo-sumo Melina do Carvalho que MD road किधर है? हेलो 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 माइक चेक
Any of the hello, hello, hello. Is it audible? What is the please tell me the condition? Hello, hello. Hello, hello. Am I audible to the all the teams who are present online?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Thank you very much.
Yes, ma'am.
Welcome, sir. Welcome, archivist. Honorable Mr. Justice Abhay S. Former Judge Supreme Court of India, has joined us online.
Ma'am, your voice is echoing. We can't hear you clearly.
Yeah. None of the students are joined online. We have not shared the link with anybody. So please ensure that you do not join the link.
उसको ये करो ना, ऑडियो ऑन करो.
Nobody comments on this one.
Ma'am, you are on mute.
Speaker on.
कैफ अभी चेक कर। हेलो।
Hello. Shall we start, sir?
Yes, please start.
Thank you. Moot courts function as a primary practical training method integrated into the curriculum of all centers of legal education. Moot courts serve as an experiential platforms to bridge the gap between practice and theory. Prospective lawyers are equipped with confidence, competence, and networks required to make a firm grounding in the ever-changing legal world. With this objective, Moot Court Society of our college, that is Maharashtra Cosmopolitan Education Society's AKK New Law Academy, Pune, has been organizing various national and international moot court competitions in collaboration with esteemed law firms and colleges. Dr. P.A. Inamdar National Moot Court Competition on the Rights of Minority Educational Institution is our flagship event of the year. Through this competition, we take honor and pleasure to acknowledge Honorable Dr. P.A. Inamdar sir's profound contributions to the rights of minority educational institutions all over India. This event is organized in collaboration with SCC Online, our exclusive knowledge partner, Live Law, Law Octopus, and Law Bhumi as legal media partners. A very good morning to one and all for today's inaugural program. I, Dr. Jacinta Stephen Bastian, Moot Court Coordinator, on behalf of Maharashtra Cosmopolitan Education Society's AKK New Law Academy Moot Court Society, extend a very warm welcome to all our esteemed dignitaries, our participating teams all over India, faculty and students to this inaugural program of Dr. P. Inamdar National Moot Court Competition on Rights of Minority Educational Institutions 2026. Joining us online as chief guest for the inaugural program is Honorable Mr. Justice Abhay S. Oak, former Judge, Supreme Court of India. The inaugural program will be presided over by Honorable Mrs. Abida P. Inamdar, President of MCE Society Pune and MMENRC and Chairman of Haji Ghulam Muhammad Azam Educational Trust. To begin this auspicious occasion, on a divine note, I invite Ms. Suhana Poshilkar to recite the Tilawat-e-Quran.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم يا أيها الذين آمنوا كونوا قوامين بالقسط شهداء لله ولو على أنفسكم أو الوالدين والأقربين إن يكن غنيا أو فقيرا فالله أولى بهما فلا تتبعوا الهوى أن تعدلوا وإن تلأوا تورثوا فإن الله كان بما تعملون خبير. For those who believe, stand out firmly for justice as witness to Allah, even as against yourselves or your parents or your kin, and whether it be against rich or poor. For Allah can best protect the both. And if you distort justice or decline to do justice, verily, Allah is well acquainted with all that you do.
Thank you, Suhana, for the sacrosanct words from the Quran. To set the tone for this national event and extend a warm welcome to our esteemed guests and participants from across the country, I invite our principal, Dr. Salim M. Sheikh, to deliver the welcome address.
A very good morning to one and all. Distinguished chief guest of today's event, Honorable Mr. Justice Abhay Oak, sir, former Judge, Supreme Court of India, New Delhi, the president of today's function, Honorable Mrs. Abeda P. Inamdar, Madam, President, Maharashtra Cosmopolitan Education Society, Pune, and President, MME and RC, Chairman, Haji Ghulam Muhammad Azam Education Trust, Pune. Honorable Professor Muzaffar Sheikh, sir, Vice President, Maharashtra Cosmopolitan Education Society, Pune. Honorable Professor Irfan Sheikh, Secretary, Maharashtra Cosmopolitan Education Society, Pune. Honorable Mr. Iftikhar P. Inamdar, Chairman, College Development Committee, AK Kinulo Academy, Pune, and all other honorable College Development Committee members, honorable management members, esteemed guests, faculty members, participants, and dear students. A very warm and gracious welcome to all of you. It is a moment of immense pride and professional gratification for AK Kinulo Academy and our Moot Court Society to welcome you to the commencement of the Dr. P.A. Inamdar National Moot Court Competition 2026. The vision of our college through this Moot Court competition is to nurture future leaders of the legal profession, to inculcate the skills of such research, their legal writings, critical thinking, communication, and bridging the gap between the theoretical and practical aspects of law. The Moot Court Society of our college, in collaboration with the prestigious law firms and the institutions such as Surana and Surana International Attorneys, Chennai, Chanakya National Law University, Patna, and Aligarh Muslim University, has been organizing such kind of a national and international moot court competitions for more than a decade. This competition, that is the Dr. P.A. Inamdar National Moot Court Competition on the rights of minority educational institution, is not just merely an academic event. It will be a dynamic forum to engage the participants in spirited debates, sharpen their advocacy skills, and uphold the principles of the Constitution. This competition will provide a platform to the participants to engage in pressing the issues of the Constitution, specifically pertaining to the rights of minority educational institutions enshrined under Article 30, Subclause 1 of the Indian Constitution. Through this competition, we take honor and pleasure to acknowledge Honorable Dr. P. Inamdar sir's profound contribution to the rights of minority educational institutions all over India. Due to sir's commendable efforts to promote and protect the rights of minority educational institutions as envisaged
This meeting is being recorded.
Indian Constitution, sir is known as an iconic architect of the Indian minorities. In organizing this competition, we aspire to honor Honorable Dr. P. Inamdar sir's legal journey by encouraging the law students, the law aspirants, to engage in an enriching legal discourse on the rights of minority educational institutions. Today, we are profoundly honored to have with us the chief guest of today's inaugural event, Honorable Mr. Justice Abhay Oak, sir, former Judge, Supreme Court of India. Sir, your presence is an inspiration. Your career has been a testament to the meticulous aspirations of the law and an unwavering commitment to the common man. To have a former judge of the apex court guiding our participant students today, it's a rare privilege. So your presence here today, it serves as a living bridge between the theory of classroom and the practice of the courtroom. We are very much thankful on behalf of Maharashtra Cosmopolitan Education Society's AK Kinulo Academy and welcome you with a big heart. Thank you, sir. I also extend my heartfelt gratitude to Honorable Mrs. Abeda P. Inamdar, Madam, President, Maharashtra Cosmopolitan Education Society, Pune, and President, MME and RC. Madam, your leadership of the Maharashtra Cosmopolitan Education Society is the reason we stand here today. You have turned a vision of inclusive education into a living reality. Madam's vision towards education is very much clear. As Madam also always used to say, and I quote, if you want to think 1 year ahead, plant rice. If you want to think 10 years ahead, plant trees. But if you want to think 100 years ahead, give education to the people. Madam, we are blessed to have your presence here today. Thank you so much, ma'am. My sincere thanks also goes to Honorable Professor Muzaffar Sheikh, sir, Vice President, MC Society, Pune, Honorable Professor Irfan Sheikh, sir, Secretary, MC Society, Pune, for their unwavering support and guidance in organizing this kind of competitions. My sincere thanks to Honorable Mr. Iftikhar P. Inamdar, sir, Chairman, College Development Committee, AK Kinulo Academy, Pune. Sir, your constant support is the engine that allows this academy to achieve such national milestones. Thank you very much, sir. I also take this moment to appreciate the Moot Court Society, the organizing faculty coordinators, and the student volunteers whose tireless efforts have made this event possible. Your commitment and teamwork are truly commendable. To all the participants, I commend your dedication and hard work. Your presence here signifies not only your academic pursuits, but also your commitment to understanding and upholding the real rule of law. I encourage you to make the most of this opportunity, learn, engage, and grow. In a moot court, your greatest weapon is not your voice, but your research and your integrity. You will face rigorous questioning, much like the fire of a real courtroom. Remember that a great lawyer is not one who knows all the answers, but one who knows how to find them and how to present them with humility and logic. I once again welcome all of you, and I wish the competition great success and hope it proves to be an enriching experience for everyone involved here today. Thank you so much.
Thank you very much, sir, for the eloquent welcome speech. We are highly privileged and honored to have with us the virtual presence of a legal luminary who has graced the highest halls of justice. Yes, it's our chief guest for today's function, Honorable Mr. Justice Abhay S. Oak, former Judge, Supreme Court of India. I now request Dr. Manisha Agarwal to formally introduce Honorable Mr. Justice Abhay S. Oak, former Judge, Supreme Court of India.
Thank you, ma'am. A very good morning to all the respected dignitaries, dear participants, and students present here. The rule of law must not remain a mere concept, but must be felt by every citizen in the protection of their rights. Today, we are truly privileged to have among us a distinguished personality and authority in the field of law, a visionary jurist and a guardian of constitutional values, who firmly believes that justice must ultimately serve humanity. I am speaking of none other than Honorable Justice Abhay Oak, esteemed former Judge, Supreme Court of India, New Delhi. With immense honor and privilege, we welcome Honorable Justice Abhay Oak, a distinguished jurist and esteemed former Judge of the Supreme Court of India, as our chief guest for the inaugural function of Dr. P. Inamdar National Moot Court Competition on the Rights of Minority Education Institution 2026. Honorable Sir completed his BSc and LLM from the University of Bombay and started his illustrious legal career in 1983 as an advocate in Bombay High Court. His journey from the Thane District Court to the Bombay High Court laid a strong foundation in civil and constitutional law. After serving as a judge of the Bombay High Court for over 13 years, Honorable Sir was elevated to the position of Chief Justice of Karnataka High Court in 2019. Throughout his judicial career, Honorable Sir has authored 371 judgments and has been part of 573 benches, contributing significantly to the development of Indian jurisprudence. Honorable Sir has given important rulings in many areas, including protecting the environment, safeguarding the rights of persons with disabilities, ensuring animal welfare, and upholding constitutional law. In August 2021, Honorable Sir was elevated to serve as a judge of Supreme Court of India, with her continues to serve with wisdom, integrity, and dedication to justice. Honorable Sir has contributed to several significant rulings during his tenure at Supreme Court of India. Notable among them are Tyananta Tamuli versus Kukumpai Kyatiki, Manipen Mankanbhai Bharia versus District Development Officer Tharod, Bar Council of India versus Bonifoy Law College, Haji Abdul Ghani Khan and Anatar versus Union of India, among with numerous others. We are truly privileged to have Honorable Sir with us today. His presence not only inspired the participants of this competition, but also reminded us that the true essence of lies in serving the society with fairness, dedication, and integrity. We extend our sincere gratitude and a very warm welcome to you, sir. Thank you, sir.
Thank you, Manisha Madam, my co-coordinator for this moot court competition. Leadership is about vision and inspiration. We are privileged to have a leader, Honorable Mrs. Abidapi Inamdar, President of MC Society Pune, whose vision has steeled new heights for our organization and achieved numerous accomplishments. To know more about the president of today's function, I request Dr. Swati Shinde to introduce Honorable Mrs. Abidapi Inamdar.
Thank you, madam. Leadership is not about a title or a designation. It's about impact, influence, and determination. Here, I'm talking about none other than President of today's inaugural function, Honorable Mrs. Abedapi Inamdar, President of MC Society Pune. Good morning to one and all. Talking about Honorable Madam, she has a keen interest in education, particularly in women's education. That's why Madam resigned from the central government service and joined her husband for serving the society by establishing various educational institutions. Today, Madam is such a dynamic and charismatic personality, strong leader, successful educationist, social worker, and whatnot. As respected Madam has active participation in educational work, she has various responsibilities in different organizations, name the few: Member Advisory Committee, National Commission for Minority Educational Institution, New Delhi, Senate Member, University of Pune, Managing Trustee, Pune Women's Council, Member, they are forced through challenges and empowered by resilience. And this is successfully proved by Madam. So with these few words, let's welcome Ma'am. Thank you so much.
Thank you, Madam. It's now time to hear from our chief guest. I request Honorable Mr. Justice Abhay Oak, sir, to share his valuable views and insights of wisdom with our inspiring young legal professionals. Over to you, sir.
Good morning. It gives me a great pleasure to be part of this function organized by AKK New Law Academy. Honorable Mrs. Abeda Inamdar, Dr. Salim Sheikh, the principal of the college, faculty members, participants, members of the managing committee of the institution, and young students. This college was established in 1994, and Maharashtra Cosmopolitan Education Society is very old. It was established in 1948. Due credit has to be given to Dr. P.A. Inamdar and his colleagues for their huge contribution to the cause of education. And I'm glad that this college has come up from 1994, and I want to compliment the organizers of this moot court for choosing the subject. I have been a judge almost for 22 years. I have seen so many moot court competitions. Sometimes I feel that the subjects chosen for moot court are cut off from the reality. The subjects are public international law or very complex issues in IPR. But the rights of minority education institutions guaranteed under Article 30 is very important issue. on which no doubt there are a large number of judgments of the courts and including Supreme Court. But this is one issue on which there has to be a debate. After Constitution came into force, number of minority institutions were set up in our country on the basis of right conferred under Article 30. I'm not going to name those institutions, but I must say that minority institutions established in our country have made a huge contribution to the cause of education. Those minority education institutions include Maharashtra Cosmopolitan Education Society. So in a sense, the framers of the Constitution must be given due credit for enacting Article 30, because this category of minority education institutions have given boost to the education in our country. Now, I must start with a regret, in the sense that I always believe that when students of law are to be addressed, that must be physical address, so that I am able to connect the students in better fashion. But today was the day when I had commitment in the evening in Mumbai, and looking to the present status of Mumbai-Pune highway, there was no guarantee that I'll come back in time to attend the other event. So I had to take this option of video conferencing. But I can assure the organizers that whenever I make a next visit to this important institution, I'll be there physically, so that there is better interaction with the students. Now, firstly, about the subject. Article 30 is one of the most important fundamental rights guaranteed under the Constitution of India. And the basis of this fundamental right is our preamble, which talks about social justice, which talks about secularism. And therefore, it will be very interesting to hear the submissions made by the young prospective lawyers on this important issue. Now, something about the moot court. I always say that today's generation of law students is a blessed generation, in the sense that when I joined law in 1980, Government Law College in Mumbai, which is the oldest law college, there used to be hardly one moot court competition every year. And that was really a formality. And now the students have so many moot court competitions at different levels. There are mock trial competitions, there are essay competitions, judgment writing competitions, and so many competitions. And that gives enormous exposure to the young generation of law students. And that enriches them also. So you belong to a very privileged generation of students. In our days, we had not heard of a full-time law course. Now all of you have full-time law course, may it be 3 years, may it be 5 years. And therefore, I personally feel that during last 30 to 40 years, the quality of legal education and standard of legal education in India has improved considerably. Now let us talk about the moot court. Moot court is a wonderful opportunity for the students to make research. It's a wonderful opportunity for students to think about the legal concepts. And another important opportunity is to face the judges, who are bound to ask you very difficult questions. And therefore, moot court serves as a great opportunity to the young students. When you are a student of law, it is not only sufficient to study law, to by heart the legal provisions. What is more important is to think about law, to think about legal concepts. It is only this thinking of legal concepts evolves the law. And moot court encourages the students to think on legal topics. I want to tell you something further. This moot court competition helps you to get early lessons of art of advocacy. Now, art of advocacy is very important art, which is different from other arts. If you are a painter, if you are a singer, some qualities have to be inborn, but art of advocacy is one art which you can learn by practice. You can learn from experience. Please understand one thing. Advocacy is not only about a good public not only about good public speaking skills. It is not only about using good language. There is something more to it. Because what is the role of the advocate? Role of the advocate is, firstly, he is officer of the court. His first duty is towards the court and not to his client, because his duty is to assist the court in arriving at correct conclusion, correct legal and factual conclusion. In fact, we began today's function by reciting few lines of Holy Quran. And from what I understood, the message given by Holy Quran is that justice must be done at any cost. There can be justice at any cost. There can be quality justice rendered by the courts only if court is supported and aided and assisted by good lawyers. So therefore, don't be under impression that because you are a good orator, you have oratory skills, or you have good command over the language, you will become good advocate. Ultimately, what is the job of advocate? As I said, you are officer of the court first. You must assist the judge in rendering justice. Now, what is the meaning of officer of the court? When you are before the court, you must tell the correct facts to the court. Some of the facts may not be in favor of your client, but it is your duty to tell the correct facts to the court. After telling the correct facts, after pointing out the entire evidence on the record, then it is your skill of advocacy to convince the court that those certain facts or certain evidence may be against your client, still your client has a good case. Ultimately, your job is to convince the court that your client is on the right side of the law and he has a good case to succeed in the case. It is important for young lawyer to understand that when you stand before the court and you know that a particular judgment of the High Court or Supreme Court is against your client, it is your duty to point out that judgment to the court, and then of course you are well within your powers to tell the court that this judgment will not apply to the facts of the case, or you can always differentiate that judgment based on the facts of the case and evidence on the record. So the first quality, essential quality which a good advocate must possess is quality of fairness. Quality of fairness is the most important quality which advocate must possess, because it is the fairness of the advocate which ensures that quality justice is rendered by the court. Because judges deal with 50 cases, 100 cases, 150 cases every day. Unless they are properly assisted by the members of the bar, they won't be able to come to a correct conclusion. Now let us talk about skills of advocacy. The best classroom to learn skills of advocacy is to sit in courtrooms, because only live action in the court will teach you what is the art of advocacy. And mind you, it is any court. In fact, my belief is that if you sit and observe the functioning of our trial courts, especially when evidence is being recorded, you will be able to understand the skills of advocacy. Now, let us talk about the skills of advocacy. Firstly, let us deal with recording of evidence. Now, recording of evidence is the most crucial part. In criminal trials, when you are appearing for the accused, cross-examination is the most crucial part. Because I must tell you that if you commit default in properly cross-examining the witness, or in a civil suit, if you don't properly record examination chief of your client will suffer forever. Because if there is lacuna in the evidence, that cannot be cured by any higher court, notwithstanding best lawyer appearing. Art of advocacy is essential part of art of cross-examination is essential part of advocacy. Now, cross-examination is not about shouting at the witness as we see in Hindi movies, we see on the screen. Ultimately, when you cross-examine a witness, your object is twofold. The first object is when you are cross-examining prosecution witness, you want to discredit the witness so that court will not believe the testimony of the witness. And the second object, and equally important object, is to bring truth on the record. And therefore, a skilled advocate must possess basic knowledge of human psychology. You must understand the witness, the psychology of the witness. There are some human beings who love pampering. So sometimes if you want correct answers in cross-examination from the witness, you have to pamper the witness in the beginning and then slowly put some questions to him which will elicit the answers which you want. There are some witnesses, some personalities where you need to attack them. You need to ask them few aggressive questions. So unless you are able to judge witness properly by understanding the psychology of witness, you won't be able to effectively cross-examine the witness. And when you cross-examine the witness, it is very important to ask correct questions. Because if you ask a question which court feels that it is irrelevant, court has power to disallow. Therefore, your questions have to be properly worded. It does happen in many cases where a young lawyer will feel that the question was relevant question which ought to have been permitted in the cross-examination, but just says, no, I will not permit you to ask that question. What is important for you at that stage is not to get angry. The skill of advocacy requires that you must tell the court that your honor is right. I will go to the next question. Because no purpose is served by fighting with the judge and inviting an order from the judge that this particular question was irrelevant question which could not have been asked. Thereafter, asked about 7 or 8 questions or 10 questions politely, and then ask the question which is disallowed in completely different language and different form. 99% the judge will allow it. The reason is that it is easy for you to take up the fight with the judge and invite a finding with reasons that why a particular question is disallowed. But if you do that, your client has to pay a very heavy price because he has to approach the higher court and challenge that order. So in cross-examination, you must remember that your object should be that right questions are asked. And you know, the most important part of cross-examination is you must have ability to think on your feet. Because in cross-examination, you can't have pre-planned questions. Because it all depends on how the witness answers first few questions. In what direction the witness goes. It all depends on examination chief. I am talking about advocates appearing for the accused. It appears on the examination. It is based on examination chief. So your cross-examination will be based on what witness says in the examination chief. You can't stand before the court while cross-examining the witness with preconceived notions. So thinking on the feet, ability to think on the feet is essential part of good advocacy. And mind you, one more thing, whether you are arguing a case or whether you are cross-examining the witness, your eyes should be focused on the judge who is sitting on the dais. When you are cross-examining the witness, your eyes should be focused on two persons. One is the judge and one is the witness. You may feel that you have asked a very brilliant question. Don't look back for acknowledgement from the people sitting in the court. Your eyes must be always focused on the judge when you are arguing a case. You should not look on your left-hand side, right-hand side, on the backward side. And staring at the witness, looking at the witness with your eyes focused on the witness is also very important for effective cross-examination. Now let us come to the pleadings part. Unfortunately, today, younger lawyers have started using AI tools for drafting pleadings. AI tools are no doubt effective. If you feed the data in the form of documents and facts, AI tool will create a nice synopsis for you so that you don't miss any factual aspect. But if you want to draft a plaint, AI has very limited significance because when you draft a plaint, you have to understand what case your client wants to prove. I'll give you an example. If your case is based on a written document, written agreement, and you want that agreement to be enforced by the court, or you want certain relief, say of decree of possession based on that document, if the correspondence made prior to the filing of the suit indicates that the proposed defendant has denied execution of that document, or has said that I have signed a document under duress, or there is a misrepresentation on the basis of which I have signed a document. So when you draft a blend, you have to imagine how you are going to prove that agreement which is already disputed by the defendant. So you have to ask the client who are the attesting witnesses to that agreement, whether those attesting witnesses will support you. You have to ask the client who was the other person, other persons who were present at the time of execution of the agreement who will support you. So after thinking about the evidence which your client is going to adduce or you are going to adduce, you have to mold the pleadings. Please remember one thing: when it comes to drafting pleadings, there cannot be substitution for human brain and human thinking. So AI cannot be the substitute. Now let us come to the arguments. If you sit in the court, you must be seeing the functioning of the high courts and Supreme Court because there is live streaming. You will find that judges ask number of questions. On admission day, if you are sat in my court, perhaps before the lawyer could open his mouth, I used to ask several questions to the lawyer. Now, sometimes you may feel that those questions are against you. So you will feel that judge has already formed an opinion against you. But the purpose of asking questions is different. The purpose of asking questions is to indicate to the lawyer that what is passing in the mind of the judge. Because unless you know that judge has certain doubts about your case, or the judge feels that law is against the case of your client, how do you answer that? If judge sits quiet, you will never understand what is passing in the mind of the judge. You will never understand what you should be arguing. But if judge makes his prima facie point of view very clear, then that helps to bring best out of the lawyer. That's the object of asking questions by the judges. And you must have seen cases and cases, say SLP arising of an order of the High Court where bail has been denied. We may ask questions in the beginning which may indicate that we may not be in favor of the petitioner accused. But ultimately, when lawyer argues, we pose him questions, so that brings best out of the lawyer. He makes best possible effort to counter what is passing in the mind of the judge. And then there are cases and cases where we express a particular opinion as judges, which is prima facie opinion, tentative opinion. We end up in taking exactly opposite view, because this is the process of judging. So therefore, it is very important for you to pay attention to the queries made by the judges. Only because queries are made by the judges, don't be under impression that judge is against you. These queries are for your benefit. These queries are to ensure that you clear the doubts in the mind of the judge. And one more thing which I want to tell you, you have to be very patient in the court. When judge is expressing point of view, you must patiently hear the judge. You know, sometimes silence is the best part of advocacy skills. So you have to understand where you should remain silent. There can be strategic silence also as essential part of skills of advocacy. And when judge is asking you a question, judge is posing a question, never try to interject the judge, never try to jump the queue. One more thing, it is true that lawyer who appears against you is your opponent, in the sense that he is representing a cause of a litigant, and that cause is completely different from the cause of your client. It is opposed to cause of your client. But please remember that never fight with your brother lawyer, brother or sister lawyer, because that is the most indecent way of advocacy. If you don't agree with the submissions made by your brother lawyer or sister lawyer, you always get a chance to point out to the court what is the correct position. Because please remember that conducting a case is not a battle between the two lawyers. The cases are conducted so that court can render justice within the four corners of law. One more thing. Now today you are in moot court. You know what is the problem, what is the brief. So you must have studied hard, you must have made research, you must have kept the case law ready, and you must have formulated your arguments. That this is your first point, this is your second point, this is your third point. In that order, you will argue before the judges of the moot court. But in court, it is not possible. I'll tell you why. I'll give an example of a civil suit. You are appearing for a defendant. You may have pleaded that the suit is barred by limitation, or suit is barred by principles of res judicata. You may have pleaded that the plaintiff is not entitled to equitable relief because he has suppressed material facts. And you may have pleaded several things which are on merits for opposing the case made out by the plaintiff. Now, at the time of final arguments in a suit or while you are arguing an appeal against a decree, suppose you start on behalf of defendant by arguing the point of bar of limitation. You will immediately realize sometimes that judge, after hearing you for a few minutes, is not with you on the question of bar of limitation. I am not saying that you should give up that point. You should not give up that point. You should argue that the moment you find that judge is not in your favor on the point of limitation, try your best to convince the judge. But the better option is then to go to your next point. If judge is not impressed with the point of limitation, go to the point of res judicata. If you find that judge is not impressed with the point of res judicata, go on facts, point out the evidence and argue on facts. And maybe before you close, you can mildly tell the judge that I know that the court is not impressed by my submission on point of limitation, but please give me 5 minutes to complete my submissions on that. And I'm sure that judge will hear you patiently for 5 minutes. So you have to remember that judges are also human beings. Judges also react in a particular manner. So I always tell the young lawyers that when you appear in a case, it is obvious that you should be thoroughly ready on facts and law involved in your client's case. But you must also observe how the judge functions. What are the views of judge in a particular contingency? You must also observe your opponent. Who is your opponent? Sometimes, some opponents, some lawyers, when you are arguing a case, especially a junior lawyer is arguing a case or conducting cross-examination, the seniors try to browbeat you so that you lose your concentration. You use your line which you have adopted in the cross-examination arguments. So you must know how your opponent is going to behave. So these are the few facets of art of advocacy. So art of advocacy again involves, apart from study of law and facts, which is the basic thing which lawyer must do, it involves understanding the human psychology. Because our system is manned by human beings, and you must understand the human psychology. And please remember one thing, that you have to always act as officer of the court. Never ever act as mouthpiece of your client. Always be fair to the court. Because I will tell you from my own experience, I have worked as a judge for 22 years. The judges like lawyers who are very fair. So you'll find naturally there is human tendency that a lawyer is fair. So judge will be more patient with the fair lawyer. If the judge knows that lawyer is not fair, he may not be that patient with you. So as a part of duty, you have to be fair, but even for practical reasons, you have to be always fair with the court, because in the few cases you may suffer because of fairness, but in the long run, fairness before the court always pays. So today you are in moot court, but please understand, after you pass out and go and argue before real court, please forget what you have done in moot court. You have to make a new beginning, because if you start treating the regular court as a moot court, you will land in trouble. In fact, I remember sitting in the court and telling young lawyers, otherwise brilliant lawyers, that I had to tell young lawyers that, look, You are not in a moot court, you are in regular real-time court. So there is a vast difference between real-time court and moot court. But surely participation in moot court is very important. That gives you opportunity to study, that gives you opportunity to present your case. There may be sitting judges appearing as judges. Last thing which I want to tell you about moot courts. For young generation, the entire world has become competitive. There are those shows on the TV, there are so many competitions. And in those shows where there are singing competitions or other competitions, you find that the losers are in tears on the screen. Please remember, even if you do not succeed in moot court, you are out of the moot court in the first round. Don't take it seriously, because this is a competition. Somebody has to win and somebody has to lose. Don't be under impression that you have not succeeded before the moot court and therefore you don't have prospects of success in the profession. No. I've been judging the moot court competitions right from my lawyer days. So I can tell you from my own experience, I know certain lawyers who are immensely successful and they are good lawyers in true sense. And they are lost in all moot court competitions. And the other side to it also, even if you succeed in the moot court competition, don't be under impression that you are superior to other students. It's a competition in which you have succeeded because of your hard work. And of course, you require some luck also to succeed in such competitions. So even if you succeed in the competitions, don't be under impression that you don't have to study further. It's a success in the moot court competition. It will definitely help you, but that is not enough. So please remember that though moot court is styled as a competition, somebody will win, somebody will lose. But what is most important is that you will get a great opportunity to express your views on law, express your views on such an important article like Article 13, which is one of the most important articles of the chapter on fundamental rights. And I must tell you last thing before I close, which I say in every law college. During last about 10 to 15 years, I have seen a completely changing scenario. When we conduct our examinations for recruiting civil judges and judicial magistrate first class, now more than 50% of the selected candidates are women. And what I have noticed further is that in most of the moot court competitions or elocution competitions conducted by law colleges or other competitions, invariably the toppers are girls. Now, this is the changing face of the legal profession. This shows, see, sometimes we think negatively about our society. We find that, and which is a fact, that after 78 years of existence of Constitution, our society is not treating women well. But this is one positive feature in legal profession I find, that now the girls are doing extremely well. And maybe after 15 years, you will find at least our district judiciary dominated by women judges. And I personally feel that, that will show success of our society, that will show success of the dreams which our framers of Constitution had. Though I personally believe, I have said so in my judgments, that when it comes to fundamental rights, we have not been able to enforce the fundamental rights the way the framers of the Constitution would have liked. Still, we face a situation where in our country, suppressed classes and minorities are not treated well. That is not consistent with the spirit of our Constitution. But I must end on a positive note about success of girls and women in legal fraternity. I thank the organizers for giving me this opportunity to have interaction with the students. I know that from what I have spoken, you must be raring to ask few questions to me, but some other day we'll do that. I wish a great success to all the students who are participating in the moot court competition. I wish a great success to the winners and losers both. I again thank the management and conclude my address. Thank you.
Thank you, sir. There is so much to say. All the points which you have given for the young legal minds over here, it will serve as a food for thought for them. All the participants who are virtually present and all our students who are present here offline. And moot court competitions, which is rightly said by you, sir, that it will serve as a wonderful platform for you all to hone your advocacy skills. So participation in moot court competitions is important. Winning and losing is not important. And to go in the courtrooms and observe, that is also very significant to enhance your legal research, to enhance your legal skills. Thank you very much, sir, for being here and virtually addressing our students and all the participants. And we really hope that you come over here and visit our campus. And we look forward to your visit in our campus for any of our future event. Thank you very much, sir. May I now request Honorable Mrs. Avida P. Inamdar, President of MC Society, to address participants here online.
Good morning to all participants, online, offline, to our chief guest, Honorable Mr. Justice Abhay Oak, Supreme Court lawyer, and then he was also justice. He was a judge of Supreme Court, and I hope you will come physically. My humble request is to come to Pune, visit the campus, and we'll appreciate your contribution to our to the law college. First of all, I congratulate the organizers, Mr. Salim and his team, and all the participants to participate at the Dr. P.A. Inamdar National Moot Court Competition on the Rights of Minority Educational Institution 2026. Sir, we started with this. We thought this is minority rights under Article 30, bracket 1 of the Constitution of India is the fundamental right in part 3 of the Constitution. And many people they didn't have. So Dr. P.A. Inamdar thought youngsters and particularly those from law, they should understand what is the spirit of this article, how it was evolved, and what is the impact or what is the result of this article. That's why we started moot court competition on this minority rights, because we feel the spirit of the Constitution is justice, then equality. We also have compassion and humanity. That is the basic. And Article 30 comes under equality. All are not equal. So minorities has to be given. They have to be protected under certain to give equality. I think that is what. I am not a student of law. I did my commerce, but I feel unless you know what is the spirit of the Constitution, that is the fundamental. Then we studied various Supreme Court judgments, myself and Mr. Inamdar, since 1950. And we came to a conclusion. Various Supreme Court judgments and High Court judgments have been given on Article 30, but people were not aware and they couldn't take the advantage of what the framers of law, Dr. B.R. Ambedkar and his team, they wanted. They also wanted educational rights, and in that particularly 2 rights have been given: to establish and to administer. Both the things, and the institutions couldn't take the advantage of these things and administer the educational institution. Hence, Mr. Inamdar thought all the future lawyers, the future judges, they must know the depth of this article, and so that the judgment can be in a better way, argument can be in better way, and justice can be given to these educational institutions. I also feel because the various acts have been framed under that has which is aligned to the constitution. Various rules are framed, various GRs are issued by various government, whether it is state government or central government, but many a times they don't go deep into it, and they just treat the minority educational institution as a general or with the majority, and they treat it, and where it is the certain things, rules are not applicable, act is not applicable, they have to suffer, they have to go to the court and spend a lot of time, money, energy, and this is how it is. So I feel all the students, I think they must have prepared for the moot court for the next 2 days. They'll be arguing, but I request them, they should understand the spirit of the constitution and how it was evolved, Article 30, who made it, and what was the purpose of putting Article 30 into the Constitution as fundamental right and Part 3 of the Constitution. This is what Mr. Inamdar and myself, that is the idea. So that whenever there is a problem, in that we have also issued various guidelines for the school education, and those guidelines have been, these have been circulated to all the education officers of Maharashtra, wherein we have covered all the Supreme Court and High Court judgments which have been passed since 1950 to 2022, and various GRs which have been issued, FAQ are also there, so that the problems, if it is there, it can be solved. I think it will be very helpful to all minority educational institutions. And minority, there are religious minorities and linguistic minorities. And as Mr. Inamdar said many a times, every Indian is a minority, because under linguistic minority, Marathi speaking, all people, they are minority outside Maharashtra. Similarly, Kannada speaking people are all minorities. So everybody is a minority in India. And they have equal rights. And I think they can take a lot of advantage, and they can also contribute to education field. And as Sir said, we have contributed a lot. Many of the minority educational institutions, they are giving quality education, and they are contributing, which the government was supposed to do, the basic fundamental or basic education and also the professional education. I hope, sir, next time we'll meet personally, and I'll be more happy to receive you at Pune at AKK Law College. And I also, put my best wishes to all the participants for next 2 days to participate in this moot court at national level. And I hope, what as sir said, winning or losing is nothing, but that will give you an opportunity to research, to understand, and also do justice or do for particular or argument under Article 30 bracket 1 of the Constitution of India. Once again, thank you very much. Best of luck to all the organizers and also to all the participants, whether they are physically or virtually they are participating. Thank you very much for giving me this opportunity. Thank you.
Thank you very much, Madam, for your words of wisdom. Madam, though you're not a law student, but you have lived Article 30, Clause 1 with Dr. P. Inamdar, sir. And because of the laudable efforts of Madam and Dr. P. Inamdar, sir, today we are in this campus where there are n number of more than 40 educational institutions which have been established on the basis of Article 30, Clause 1 of the Constitution, protecting the rights of the minority educational institutions. Madam, we really acknowledge the efforts being taken by you and Dr. P. Inamdar, sir. Thank you very much, Madam, for addressing the students virtually and all the students present over here. Thank you, ma'am. To wrap up with our inaugural program, I request our Vice Principal, Dr. Atul Zarkar, sir, to propose vote of thanks and to thank all those who made this event a success one. Thank you. Please.
Respected dignitaries, distinguished guests, faculty members, and dear participants. It is my profound honor and privilege to extend sincere vote of thanks on behalf of MC Society's AKK Nula Academy at this inaugural function of Dr. P. Inamdar National Moot Court Competition on the Rights of Minority Educational Institution. First and foremost, I extend my deepest gratitude to our chief guest, Honorable Mr. Justice Abhay S. Oak, sir, former Judge, Supreme Court of India, for gracing this occasion. Special thanks to Mrs. Abeda Inamdar ma'am, President MCA Society Pune, President MEMRC Pune, and Chairman Haji Ghulam Mohammad Azam Education Trust. I also straight thanks to Professor Muzaffar Sheikh sir, Vice President MCA Society, Professor Irfan Sheikh sir, Secretary MC Society, and Advocate Iftikhar Inamdar sir, Chairman of CDC of our Law College. Our sincere thanks to our knowledge partners, SCC Online, Law Bhumi, and Live Law. Their support strengthens our mission of promoting the legal awareness and advocacy. To the organizing committee, faculty members, and student volunteers, thank you for your persistent efforts and dedication in ensuring the seamless execution of this event. Your hard work behind the scenes is truly commendable. I would also like to express my special gratitude to college management and our respected principal, Dr. Salim Sheikh sir. Finally, to our brilliant participants, we wish you all the best for this competition. With that, I once again extend my sincere gratitude to each one of you for being part of this event. Thank you and best wishes.
We have come to the end of the inaugural program. I request all the participants who are virtually present to be present, to be online. We take a break of 10 minutes and we move on to the draw of lots and the orientation program. And all the students who are present offline over here, if you desire, you can wait over here, or if any of your assignments or any other lectures are there, you can move forward for it. But please give your attendance.